Hello, and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. How one hospice owner got convicted of healthcare fraud and how you can avoid that fate. Jonathan Porter.
Hi, Meg.
My wonderful colleague. So we're here to talk about, something that didn't go so well for one hospice, and sort of lessons learned from this. So maybe to kick off this case, can you, and we can link to the case in the podcast notes. So if people want this reading before they go to bed at night, they can do that. But, tell us what this case is and what's it about and whatnot.
Yeah, absolutely. Thanks, Meg. Good to be back with you. So let me first give a caveat. I was not involved in this trial in any way. I'm working off of the publicly available docket plus media reports. So I'm doing my best here, but this is essentially a case about a doctor in New Orleans named Dr. Shiva Akula. Dr. Akula is an infectious disease specialist, but he on the side owned this hospice in New Orleans. He wasn't the medical director, wasn't certifying patients. He was, doing his thing as an infectious disease specialist, and then owned a hospice on the side. So he was indicted, and we can talk about how the steps that led up to his indictment. But he was indicted for healthcare fraud. A lot of federal indictments these days, they've got a lot of legal theories. It's sort of typical in a healthcare case that you'll see not just healthcare fraud, but also conspiracy counts, and kickback statute violations, false statements. Sometimes you'll see aggravated identity theft. But here, this was very
wow.
Yeah, that's modern.
Aggravated identity theft. I won't
yes.
go down that rabbit hole. Like, what is that? But okay.
That can be a follow-up podcast, Meg. The people will be emailing requesting that follow-up for sure. No, but here this was a simple one, just healthcare fraud. But it's the losses here are large for a hospice. $62 million billed, $47 million paid in what the government claims is fraudulent conduct. There were several theories of wrongdoing. The main one that we should focus on is that Dr. Akula was essentially accused of having the hospice auto-enroll patients in GIP, or general inpatient care, people who just didn't need GIP for, at least according to the government. What the Justice Department says general inpatient care is, and they spent a lot of time explaining this and how general inpatient care relates to respite care in the hospice setting. The Justice Department said that general inpatient care should rarely be used by hospices, and really only when there's pain control or symptom management issues that can't be provided in anything but inpatient care. And DOJ is careful to contrast that with respite care, which it says is for the occasional relief of family members who are caring for a patient at home over a long period of time. They just need a break. But the big distinction that the Justice Department draws between those two is that Medicare reimburses very differently for those two. So the Justice Department says that during the time Dr. Akula was pushing general inpatient care, Medicare was paying around $170 per day for respite care, but over $700 per day for general inpatient care. And according to the Justice Department, that's why Dr. Akula was enrolling patients in general inpatient care. It was to essentially 4x his Medicare payments.
Yeah.
Now, Meg, that's DOJ's allegations of how general inpatient care works. And to be honest, that makes sense to me. It's, it should be rare because you think about patients wanting to, they want to be at home as they're going through that process and everything. But I'm curious, what's your experience with general inpatient care? How do you advise clients when it comes to that?
Yeah, well, I think that it is rare, and there's actually a cap for overall general inpatient care. It's like no more than, I think, 20% of your days can be GIP. No one in my nearly 25 years have I ever heard have gone over the GIP cap. And I think if you were going over the GIP cap, which I wonder, like, given this was probably a pretty small program and that's a lot of GIP billing, like, I wonder if there was a GIP cap issue there. But, it is rare. I guess I wouldn't say rare. I think that it's possible that people may need that care. I think there's a lot of push-pull right now with the government. The OIG is doing a big GIP audit. There's a lot of TPE going on for GIP. And I think that this is not in the false claim context, but some level of disconnect between what the government thinks qualifies for GIP and what hospices think covers GIP and what the regulations say. Because sometimes when you deal with medical review of GIP, it's sort of like, oh, today's Monday, they would be eligible for GIP, and then they're not eligible Tuesday, but then they're eligible Wednesday. And it's like, no, that's not, how this would work. Because, usually people, it could be a step down from a hospital, or, they're having it, you're trying other things in the home that just aren't getting those symptoms under control. You're not going to send someone back home if their symptoms, okay, you're not screaming out in pain for an hour. I'm not going to send you home hour 2, right? Like you got to see if that holds and stuff. And so I think there's real tension about how that looks. And then, we've used this case on a number of occasions in advocacy, like people denying GIP when someone is vomiting feces. Like that's not a normal occurrence. So you think the family could handle that in home? So I think what is unfortunate is there's a lot of, I think, valid GIP going on that is getting denied. And then you have someone like this where it's like, this person's so off the rails. Why is everyone getting, all this scrutiny? And they're not doing, this. And, I think that is always, people listening to this will be like, oh, this clearly it wasn't a good idea what this guy was doing. And I'm not doing that. Why do I keep getting, this kind of scrutiny? And, for this hospice, it sounds like this was going on for a long period of time, and it's like, I think everyone's like, go have at it, government, go get those folks. But anyway, it's, I think, interesting when you look at these cases, the claims we're talking about, this is 2014, right? Some of this stuff, this stuff is old. And when you think about hospice, that feels like ancient history, ancient, and so, but so I think most people will be like, yeah, that seems really weird that, so many people would be on GIP. And it seems like the government really feels like this was respite level of care. Like there was maybe relief of the family, but it was relief of the family from more custodial care than actually acute skilled care that was needed. But anyway, so this goes to trial. Jonathan, so this wasn't a settlement case, right? This
Correct.
Went to trial.
Correct.
So, which, oftentimes things are settled. So that's a little bit, were you surprised at this, because and maybe for our listeners who forgot, you were at DOJ for quite some time and did healthcare cases. And so you have sort of a unique insight, because it's not like, how many of your cases really went to trial? Trial is such a rare thing in litigation, right?
Yeah, trials are definitely rare. The Justice Department has a really high percentage of winning cases that they indict, and so the vast majority of criminal cases are going to plead out, and even more than that on the False Claims Act side for a lot of reasons. Those are going to resolve prior to trial. So these trials are actually very, very rare.
And so was this a criminal case, Jonathan?
Yes. Yes, this was a criminal conviction above and beyond. It was, so there was also a False Claims Act qui tam, which we could talk about. But in addition to the qui tam, this was a criminal case. Dr. Kula was indicted.
So there was a third-party whistleblower, which is what got the government in the door to begin with, because the government didn't flag this on their own. It was the whistleblower that brought this.
Yeah, that's exactly it. So this case has really interesting history that we could probably learn a lot from. So there's a routine audit back in 2014 that the MAC did, and there was a 100% failure rate for this hospice. After that 100% failure rate, apparently, Dr. Kula just kept doing what he was doing, exactly what the audit failed him for. He just kept doing the exact same thing, according to the Justice Department. And then a few years after that, one of his employees filed a qui tam. So the way qui tams work, Meg, and you know this, but some of our listeners may not, qui tams are filed under seal in federal court. No one knows about the existence of that qui tam except the court, the person who filed it, and the Justice Department. Now, the Justice Department then investigates for however long they want to investigate for, or however long the courts will let them investigate. And then they'll make a decision whether to take the case or not take the case. So in this particular case, the qui tam was filed 7 years ago. And for 4 years, Dr. Kula had no idea that the qui tam had been filed. For 4 years, the whistleblower continues to work for the hospice.
Wow.
In those 4 years, she took documents. FBI had her make recorded phone calls to Dr. Akula. And at one point, it appears she even, shook Dr. Akula down for some money. Just bizarre facts here. But the FBI investigation took a really long time. And Dr. Akula was actually finally indicted in 2021 for these charges.
Holy cats. So, and maybe this isn't something but is that, I guess when we've dealt with whistleblowers, oftentimes it's like a former employee or something. I mean, because the thing that might be rattling people hearing this, like getting anxious, like you're always being recorded by your employees. But is that common when someone files a qui tam that then they are then cooperating with the government? Like, I guess where's the line there that, like, you're now an informant, so you I'm thinking, again, TV show here, like I'm wearing a wire, like, is that, like, if I file a whistleblower, am I required to do these things the government wants, or am I sort of a willing, like, oh, I could or could not? I mean,
yeah, good question. It depends. It largely depends. So whistleblowers are tremendously incentivized to do what the government wants them to do. Most whistleblowers, when they're filing a qui tam, they want the government to take the case. Their cases are always going to be stronger when it's the government saying that person over there committed fraud, rather than if the government says, we really don't like this case, and it's, a private attorney saying that there's fraud. It's always stronger when the government is making the argument that there's fraud. So they want to be 10 times out of 10, the whistleblower wants to be really cooperative with the government. If the government wants them to make recorded phone calls, they're going to make recorded phone calls. If the government wants them to go in and take documents, which is a different issue, and is a lot more complex. It's a longer conversation, but they're going to go do what the government tells them to do. They're going to go take the documents. They're going to make recorded phone calls. They're going to do whatever they can to make that case good, because they know at the end of this, if you settle for $1 million, you're going to get, 6 figures out of it for sure. And so they're wanting to be helpful. They're wanting the case to go well.
Wow, this is like a movie, Jonathan. I'm just thinking about.
We could turn this into a screenplay, Meg.
Yeah, exactly.
Viewed by dozens of people. Yeah.
Yes. In my retirement, I'll start. Yeah, all the crazy stories that went on. So, okay, obviously they're building a very, very strong case. And maybe one side note too, since this is a criminal case, and the whistleblower's interest is at least maybe partly money here. I mean, obviously he's going to jail, right? But is there money to collect here? Obviously we want bad actors out of the program, and now he's going to jail. Like, is it hard to recoup that? Because how much is the repayment back?
Yeah, that's actually so I glanced right before we recorded this. I glanced at the docket, and there apparently the government and Dr. Akula are fighting over money.
Okay.
The government's worried that that Dr. Akula is moving assets, which you're not supposed to do once you've been indicted. That's usually part of some standard conditions of release on bond, is that you tell the government before you're going to move funds around. And so the big question here is how much money is left. A lot of times in these cases, the lawyers get a decent chunk of change. Sometimes there's not a lot of money left over. That largely depends on what the defendant's financial situation is. But yeah, that's usually a factor. Is there going to be money left over?
So the whistleblower, even if they could get whatever 30%, there might not be 30% of zero is zero.
Yeah, so you could get a really nice judgment, I guess, that you'll never collect on. It'll be very impressive. You could get a big fake check to yourself, but you won't actually collect anything if there's no money left over.
Okay, so all of those recorded phone calls and blah blah blah. Okay, wow, what a story here. So obviously there's no settlement, which seems sort of strange if you have recorded phone calls and all these other things. But okay, so no settlement, you're going to trial. So what do they have to prove at trial, since this is a criminal healthcare fraud case?
Yeah. So most of our cases, Meg, in the hospice industry are civil under the False Claims Act. Civil cases have a really low burden. It's what's called a preponderance of the evidence. It's essentially 50% plus one little bit, just a little bit more than 50%. The criminal burden is amazingly high. It's beyond a reasonable doubt. You have to show with a fraud count, you have to show intent to defraud, you have to show willfulness. Dr. Akula his jury was instructed that to convict him, they had to find beyond a reasonable doubt that he had like this bad purpose, this intent to actually cause harm to Medicare. And the big thing is a mere misunderstanding of, the technical points of a CPT code. That's really not enough to show bad intent. And the way DOJ went about clearing that really high bar at trial was mainly through witnesses. So they had a bunch of Dr. Akula's former employees testify against him. One witness was a medical director who testified that he had charted that patients were stable, but then someone else went in and changed the charts to distressed. And I guess that was to support inpatient services. So that was if you're a hospice listening, don't go in and change your medical director's charts to support fraud. Another witness was a former employee who testified that she told Dr. Akula directly that they were treating patients who didn't qualify for hospice. You had the whistleblower herself, the one who filed the QTAM. She testified against Dr. Akula. And then the hospice administrator testified and was probably one of the key witnesses against Dr. Akula. The media, I read some media reports on this that said that the administrator previously pled guilty to a felony. I couldn't find that anywhere, but apparently what she pled to was that she changed patients' charts to qualify for them for GIP. And that's what she pled to. But, fascinatingly, she wasn't willing to testify that Dr. Akula instructed her to change charts. It was a really complicated story, it sounds like, not very clear. Sort of like an indirect pressure thing. But, based on court filings and media reports, I'm actually a little underwhelmed with the government's evidence against Dr. Akula. The case appears to be that, one, Dr. Akula had direct control over billing. That's important. Two, the audit where the hospice 100% failed, that put Dr. Akula in notice that the billing was wrong. Three, Dr. Akula signed that standard Medicare enrollment paperwork that put him on notice that he's got it, which is, I think that's always a bit nuts. Yeah. And then four, that Dr. Akula, as the owner, was the one who financially benefited from submitting these improper claims instead of claims for respite care. that evidence is not all that strong as far as federal criminal cases go. Part of what the government needed to prove was intent to defraud. That's like a bad or evil mindset. I don't see evil in that evidence necessarily. A lot of that is like should have known evidence, which is not enough in a criminal trial. What's interesting is the government filed a pleading in December that addresses that intent to defraud problem. And their position is pretty unusual. The prosecutors say that the nature of the scheme is, quote, not a fraud that could have been committed accidentally or negligently, unquote. I'll be honest, I don't love that argument from the Justice Department. CPT codes are really hard, Meg, and people get CPT codes wrong all the time on accident or through negligence, sometimes intentionally. Intentionally is fraud, but accidental or negligent doesn't mean fraud. So to me, that's just a bad argument by the Justice Department. In addition to the, CPT codes can't be accidental or negligent argument, the prosecutors pointed to witness testimony that billing for inpatient care is unusual in hospice. But that doesn't remotely say that Dr. Akula, knew that it was wrong. That just means that it's like objectively wrong for people in the industry if you had that knowledge. So the evidence, at least from my limited vantage point, doesn't appear to be all that strong relative to what I'm used to seeing in criminal healthcare fraud cases. But the jury still unanimously convicted Dr. Akula of healthcare fraud. It did so rather quickly. Under 2 hours of deliberation, which is quick. And I'm not saying that it's the wrong decision, just that the evidence was not overwhelming to me. Knowledge from that audit was probably a big deal. Control of billing was probably a big deal. Profit, definitely a big deal to the jury. A lot of juries are going to vote to convict based with just those three, and it did here. So now he'll be sentenced sometime later this year once the court does all the full report on the conduct and the factors and everything. But it'll be a long process for that.
Wow. See, this is why you're a defense attorney now. It is just like when, and I'm not a criminal defense lawyer, but it's like, oh, geez, someone's got you recording. I mean, who knows what. My guess is if you're trying to record someone and get them to admit something, there needs to be some subtlety so someone doesn't think that they're being recorded. And so, but I mean, I do think like this just, well, I think a lot of things. I think your point about the, the medical review and they had 100% error rate. Now, this is, different circumstances, but so often people have high error rates and then you go through the appeal process and then you get everything overturned. And so my guess is they weren't appealing these claim denials or whatever. You just sort of took it and went away, and went on doing whatever. But I just think that, all of us have a lot of concern where you look at the beginning of the story and then you don't see like, well, did any of that stuff get upheld? Again, I'm sure here they just sort of took their lumps and then, as you said, just kept on doing whatever they were doing as opposed to, oh, look I proved the government wrong and got all these denials overturned. Just so, listeners aren't thinking like, oh, geez, I had a really high error rate in some TPE or even a UPIC. I mean, that the government from a, criminal fraud perspective isn't just looking like, oh, you had a bad TPE result. They're also, that's not going to necessarily get you in the fraud realm. I mean, here, my guess is it was really high. You never contested it, right? And so when we work with clients, it's always very important to do at least a first round defense on things. So it doesn't look like an admission that you agree with denials. Sometimes the cost benefit isn't there from a money standpoint. I mean, here it was probably worth a fair amount of money, but if certain claims are denied, I mean, hiring lawyers and doing all this stuff and going through a 4-level appeal process costs a lot of money. And so some people will be like, I'm not going to keep throwing money after this. I'll just sort of move on. But I think it, always a good reminder that, the government's going to look at that error rate and you want to be able to say, at a minimum, you went on the record about why you disagreed with stuff, as opposed to just because doing nothing makes it seem like I agree and this is an admission that this isn't right.
Yeah, and that's the big takeaway, Maggie, is you got to take audits seriously. I mean, one of the hardest jobs of that a federal prosecutor has is to show what a defendant thought in a given moment. That audit in 2014 effectively put Dr. Akula on notice that he had done something wrong. And by just plugging away, billing away as though nothing had happened, he took on a ton of risk that ended up getting him prosecuted. That audit to me is sort of critical to showing that he knew what he was doing was wrong. And I don't think he's getting indicted without that audit. So, jurors oftentimes they're going to reduce things down to simple concepts. And that simple concept is that the audit told him not to do it and he did it anyway. And $47 million later, that's not, a jury's not going to say that that's an okay thing. They're going to do something about it. So if your audit comes back with a 100% failure rate, you got to either, exactly what you said, Meg, you got to either contest it, you got to make some changes, but continuing on as if nothing had happened, that's just a bad idea.
Oh, it's just a cost of doing business.
Mm-hmm.
I'll just keep plugging along. But I do think in the audit activity is so fast and furious right now. It is really important to put your best foot forward and not just say, well. And I would think most people are not doing this, at least folks that we work with, like, well, I guess I'll just change things going forward. And it's like, yeah, but you still want to get on the record that you disagree with this. And there's a reasonable basis for why you did what you did and what you thought you were doing, right? When you submitted this claim, you thought it was billable. Well, why, mm-hmm. right? Like you have documentation to support that. And as we all know, the clinical decision-making for hospice is, inexact, right? I mean, GIP is also a somewhat fuzzy standard, right? Like, could this be managed at the home? Well, maybe it depends on, what resources you have. And I mean, there's a lot that goes into, these different things. And so I think if you're billing something, most people have a basis, right? The physician ordered that level of care, right? They thought it was medically necessary, and then they're reviewing it, on a daily basis, most people. And so I think you're right. And it's a reminder that not like this is going to be the end result for people who get a bad audit. They're going to get criminally indicted. But I just think, bringing it back to what a lot of people are dealing with is audits and taking them seriously because they can be used in evidence and probably criminal or civil fraud. And so we know that is actually happening. But geez, this is just like intrigue and all of this. It's so mundane now when you're on this side of the fence, right? Like, oh, this is just, I can't even imagine when it's like working for the government, all the things you see.
Yeah, it's exciting on this side too. For sure. Yeah. Mm-hmm. Fewer recorded phone calls.
Yeah. It's just so fascinating when you talk to, former government lawyers, because folks are always so worried like something horrible is going to happen to them. And then you're like, people just don't have perspective of the things that, people are doing out there are, not what people who are calling me worried about something. It's like that. This is not what is going to get you in jail or any, no one is. So I just think you see a whole different side of life when you're working at the government of strange behavior. So, yeah. So, well, fascinating case. And I guess it will, as you said, take a while to figure out if there's any money left at the end and what kind of sentence. But I would expect something fairly hefty.
Yes. So the loss amount is what largely drives federal sentences in fraud cases. And when you're up in the $40 million range, you can expect a large sentence.
Ugh. Mm-hmm. Not a happy ending there.
Not at all.
For Dr. Akula, at least. Anyway, well, thanks for this exciting pitch on a screenplay. that just happens to be real, right?
That's exactly right.
So, but anyway, well, thanks as always for lending your expertise, and it's just so great to have you as part of our team.
Thanks, Meg. I appreciate you letting me on your team.
Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.